like I think I've said before, what would have been good, although it's difficult, it's unfair perhaps, but what would have made sense is to say, here are my petition signatures. They're not valid under the current scheme because the person who circulated them is not a Virginia resident, but I have them right here, and I want them counted. If they had done that, which would be a little tricky because it might actually be illegal to collect the signatures, but if they had done that, or had done it earlier, the outcome could have been very different. If they had gone to Judge Gibbons and said, here they are right here, please order them to count them. But his problem is, what are you going to do now? Go out and start collecting them? So they were testifying all about if we were ready, we weren't able to, we had all those people ready to go, and like Huntsman said, he had buses of students lined up in the District of Columbia, ready to come over, and they couldn't do it. They're all trying to show the judge this, but for this signature, we could have complied, but this provision stopped us. Now, of course, I do have to say that if you had thousands of people nationwide who could have come to Virginia, you're telling me you couldn't find anybody in Virginia? That doesn't quite make perfect sense to me. And like I said there, I did actually sign a petition from somebody who was actually in my district. So they found some people. They also challenged the issue of the 10,000 total. They said that 10,000 was too much, and Judge Gibney was not impressed by Judge Gibney in terms of the constitutional analysis. He thought that the 10,000 total was not a big enough burden to question. He accepted that as legal and constitutional. They also challenged the 400 congressional district, 400 signatures per congressional district. Now what's interesting is this all happened very easily. When you start a lawsuit, you're lucky to be out of it in a year. This was filed, what, December 27th, I think? Technically what happened, and many of you may not really care about this, is that yesterday was a preliminary hearing. So they were asking for an order to order them to be on the ballot on sort of a temporary basis. But technically the lawsuit is still there to go to final hearing, which of course is completely useless because the primary will be over by the time it's handed in. So it's really kind of an odd procedural posture that it's in. But one of the reasons why it was so difficult for them to win was because the rules on getting an immediate temporary injunction are much harder than if they could go to a final hearing. So it was a high burden for them to overcome. And that's one of the reasons why he applied for that, but that gets into a lot of technicality. One of the other things that came out very interesting yesterday was, as I said, the campaigns were all up there testifying about, we could have done this, we could have done that, here's what happened, here's how many we submitted. You know, one of the things that bothers me is the State Board of Elections, they didn't know anything. When they said, well, how many did this candidate and that candidate submit? We don't know. At least as far as that goes. Newt Gingrich said he submitted over 11,000. The State Board of Elections said, we don't know how many he submitted. The same with, so I was really kind of struck by their lack of interest and lack of details as far as that goes. Now, they are submitted, excuse me, and I don't, sometimes when you try to focus on the latest news, I tend to skip over sometimes some of the background. It's kind of it's not that I don't care about it, it's kind of torn between the latest news and the background. The process as it has is the petition signatures are submitted to the State Board of Elections. The State Board of Elections then turns them over to the party, whatever party it is, or if it's not really one of the major parties, it's some organization equivalent. And the party then counts them. And technically, the way the statute is worded, which is very strange, is it doesn't say, I was asking David Ray earlier, does the local unit have the authority to choose a primary convention, or does the state party as a whole have it? Here, the way the statute is written is the chair individually is named in the statute. It doesn't say that the party as a whole votes, or the state central committee votes. It's the chair of the party acting alone is charged with state law to count, technically, if you want to read it that way, he's supposed to personally count them all. He's supposed to count the petitions and certify to the State Board of Elections who qualify. It seems to serve absolutely no purpose except to hide the ball, to make it as difficult as possible to know what really happened. Because why did the State Board of Elections gets them, hands them over here, and then gets them back again? The round trip does absolutely nothing except make it, invisible as to who actually qualified and who didn't, and make it very difficult to find out. So that's why I was a little struck by the fact that the decision is they didn't qualify, but nobody can tell us why. Nobody can give us exact specifics.
Is it not true also that they are not required to keep the ballot so that if there's controversy that can be reviewed, they're allowed to shred them on the
I think, and I understand it has happened.
In the case of in this particular case, my understanding is that they kept everything because in the case of the Gingrich petitions, there is an allegation, and I want to emphasize allegation, that something on the order of about 100 sheets are filled out in the exact same handwriting by one person from Henry County. And the state party staff says that nonetheless, even though they looked like about 1,400 signatures all in the same handwriting, they said, well, we went through, we checked them all anyway, we just looked them all up. We looked every last one of them up. And they asserted that they couldn't find a single one of those names on the voting list. All 1,400 names were fictitious. So at that point, they thought they might have a problem. Now, once you subtract that 1,400 from the Gingrich total, you no longer have the 10,000 because they couldn't find those names on any voter roll. The Gingrich campaign has subsequently admitted, yes, our guy did defraud us, we admit it. We're angry about it too, they say, but our own guy screwed us. Okay, that's what they say. So RTV kept all of those should a judge ever order them to be handed over as evidence in a criminal case against that one guy in Henry County. In other words, they kept the evidence in case a judge somewhere orders them to hand it over, or in case they're subpoenaed by a Commonwealth's attorney. But at the moment, the last I heard, nothing has happened about that. And my guess is it's possible that it might, it's also possible that it might not. But they say that they kept it all. It's all supposed to be locked in some safe place that Pat Mullins himself would never touch, etc., etc. So they claim they've got it.
It's up to them what they do.
Until a judge orders them to do something, yeah.
Can I personally sue that guy? just want to know.
You can file out a complaint.
What role did the Attorney General play in all of this?
Well, let me explain. Yeah, I'll touch on all that.
I just want to ask, is when the state board
We can't hear. We can't
I'll
hear.
repeat it.
that they didn't have the count, didn't the judge look to Pat Mullins for the count? Or was it just dropped at that point?
Well,
Excuse me, what was the question?
the question was when the state board said they didn't have a count, didn't the judge ask Pat Mullins? That kind of goes to, a lot happens in court depending on who puts on their presentation. Probably a lot of cases are won or lost based upon whether somebody thinks they asked the question. And that, they should have called back that, Pat Mullins and asked the question, but it just wasn't asked.